to address this matter.
I'm sorry?
So I'm Thomas Styron, the living man, not Thomas Gilbert Styron, the entity you know me as, or as I'm on the papers. I'm here to address the matter.
All right, thank you. Did you wish to be represented by an attorney, sir?
No, I'm here to address the appropriate persona.
All right, everyone, buckle up because today's courtroom session is anything but ordinary. We have a self-represented defendant challenging the very rules of the court, citing religion, indigenous rights, and international declarations, all while facing serious felony charges. Will the judge bend, or will order prevail? Stick around, because the tension is real, and the drama only escalates from here.
All right. I do have to advise, so you're going to represent, you need to stand in the middle of the podium where he's telling you to stand.
Check back there. I'll take the console.
I don't know that we're going to be doing all that, but let me ask you something. On the Styron matter, I sent my bailiff back to get him to bring him back out. The court is of the understanding that defendant number one is being, I will say, uncooperative, has purposely done some things to make it difficult to bring him out. What I'm going to do at this point in time, we're not going to wait and not going to play his game. We will hear him next week because of his behavior today before the court. At this point, I will revoke his bond and I will adjourn the probable cause conference. He certainly poses a risk to even bring him out. So I will adjourn this out to May 2nd, 2024, 9 a.m. or as the invite indicates. I will leave it there for the reasons that I've stated on the record. Mr. Mansour, he is not represented by counsel. If you would, for the court, take the opportunity to go back and to apprise him that of what the court has done and that I will see him next week. The court feeling that he's being uncooperative and not compliant. All right. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Tariq Day.
I am Tariq Samaritari Kade, the executor of the Tariq Samaritari Kade Living Trust and the registered owner of the Tariq Samaritari Kade Ex Relatione Kindaman Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the third degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant to me. I am indicating that in this proceeding, you will be required to abide by the rules of this court Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role. If
How what?
how religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No.
So I do have.
Sir, what you're about to state is incorrect.
Well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules.
Is there a
You are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution as well as the court and the officers agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this.
Yes, sir.
Because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion. Yes.
Pardon?
Under threat, duress, and coercion. Yes.
No. It's not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes.
Pardon?
I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
The court ask the people to prepare the order for the competency.
Yes, please prepare the order for the competency, if you would, sir.
And the address for,
The defendant,
I see on the complaint is 14.
is that your address, sir?
Excuse me. That's correct.
All right. All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry. Can I get that date again, please, sir? If I can put it in my calendar.
July 25th, you were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I did. I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it. I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what you stated at the last hearing.
well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. Young man, you're gonna
That's it.
figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear it motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay. No problem.
Is that it for me? Thank you, Ann. Thank you, Alan. Thank you, Em. Court, say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn. The very first case, when you say the first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. All right. Court does call the case, People State of Michigan versus James Whitley.
People.
Your Honor, for the record, my name is Defendant. Mr. Stand to the front, certainly state your name. James Thomas Whitley.
This is a continuation of the hearing. Is there anything additional from the people?
Nothing additional from the people.
Anything additional from the defense?
Nothing, yes, Your Honor. One thing additional is that if the court finds that money bail is necessary, I believe that based on this case, the appropriate bail would be something like a $10,000. the current bond conditions regarding specifically a GPS tether with the exclusion zone and the drug and alcohol testing, I think address what the primary concerns are in the report. He was intoxicated, and of course he should not be driving. But the reason I think primarily that the $150,000 surety bond is excessive is he has no history of any violence whatsoever. In fact,
Well, can I just stop you there? Because I have some concerns about the representations of what happened that were made to the magistrate at the time, and some of them made to me yesterday. I went back and listened to the arraignment. And my understanding is that the alleged victim in this case contacted the defendant to pick her up from Chelsea bowling lanes or something along those lines.
he went to Chelsea Lanes to make sure she got home safe because she was intoxicated.
Right. And then after that is when this ensued. I'm having difficulty. Well, let's put it this way. According to what I have, he shouldn't have been driving. That's number
Well, he
one.
wasn't tested. The allegation is that he was intoxicated. I don't believe he reasoned that conversation.
Mr. Bennett, do you know what you said at that hearing regarding intoxication? Well, first of all, I don't think there are two issues there. One, he wasn't supposed. My understanding is his license is revoked with restrictions, and that his activities in going there that night would not have been within his restrictions on his license.
Okay.
Right? Secondly, with regard to the incident, the indication is he was trying to get his keys to then drive again, which would have been outside of his restrictions on his license. And there was at least the indication when there was a talk of intoxication that the defendant at that time may have been intoxicated.
I believe I said exactly that. He may have been intoxicated. Can I address that concern or not?
Go ahead.
Your Honor, if that's the concern is that he was driving when this happened, then an added condition of he can't be driving without a valid license.
No. My problem is with the whole story. Because why is he getting his keys to drive when he's not supposed to be driving? Is what I'm having difficulty even understanding the events as you're telling me they may have existed at that time.
She was intoxicated at Chelsea Lanes. He wanted to try to drive her home. She refused. She drove herself home. I haven't seen the alcohol test. I don't know whether it actually touched or not. He followed her home to make sure she got there okay. The parties he had generally, I believe, according to the report, it's spent most nights there. Then they got into an argument and he tried to leave, couldn't find his keys, and that's when the incident with the bed, the phone, and the glass break. I think, in my opinion, those sort of discrepancies are only guess the absolute truth, I guess, would be relevant to the bond, but they decrease the likelihood of conviction when you have the alleged victim saying that her statements were entirely accurate, and wishing to recant, and him saying he was looking out for her. When the argument got loud, he had asked her to keep it down so the children wouldn't hear them arguing because he.
Notice how the court weighs the evidence here. Multiple conflicting stories, injuries requiring medical care, and the defendant's history of ignoring rules. This is a classic scenario where bond isn't just about guilt. It's about potential danger to the victim and community. The judge has to balance risk, credibility, and public safety, which makes these deliberations both complex and crucial.
Concern about trauma they experienced from a prior abusive relationship. And telling her to calm down actually escalated the fight, and that's when the incident happened in the bedroom, which there's a disagreement about what that was. That, at the end of the day, resulted in the injuries that were sustained by the alleged victim to her wrists, her arms, and a head. I would clear up, since you gave me a chance, there were actually, I believe the people said there were 3 CAT scans, there were 4, there were 3 x-rays. I was able to do what they provided. But I think that the key issue in this bond is somebody who is a close friend, the alleged victim, has known Mr. Whitley for 20 years and said he's not violent. This has never happened. So, regardless of whether or not there's a conviction for purposes of bond, he does not pose.
If I consider him a danger, yes. I mean, what I've got here is I've got somebody that shouldn't be driving, who may have been intoxicated, who would have driven on 2 occasions when he's not supposed to be driving, in violation of his restricted license, breaking the law. Then I have this confusion about the incident. I don't even know why she would have his keys if it now is you're relating to me that he drove and then followed her, which was not the indication that I got from listening to the arraignment. And then an altercation occurs that results in what I would consider significant injuries to the alleged victim in this case, to the point of a level of medical care that was required regarding that person, which I think would have been significant. And then from that, does she have to keep moving? And then, it creates in this court's mind a level of potential danger that this individual poses, potentially to the victim as well as to the community. It certainly raises that level because he's not this law-abiding person that you say he is, because he's obviously driving. I mean, he's got those previous convictions, which led to the revocation of his license, which led to the restriction, and he's violating that twice that night, at least. So, I don't know. Rosa, was there something else?
No, you're right.
Anything else, Mr. Bennett? Anything else, sir?
No, I just don't know. I get that he was driving when. It's violating his restriction. That doesn't want $180,000. You think that some cash bond is appropriate at this point. I think it should be something that policy. Especially in case that the likely sentence probation.
Understood. And what I am additionally indicating is that in listening to what was the representations at the arraignment regarding what transpired, listening to what transpired that day, hearing what is today, it's unclear to me that that's what actually happened. Because that's not what's been said on the defense side about how this whole thing comes about. I then end up with an individual that is severely injured where they're at the hospital getting the treatment that they're getting. There's some indication that that's her fault. Maybe. But then, and that the defendant is trying to get away. I just find that version of events, it may indeed be true, but I find it, at least at this point, to be sort of remarkable that that would be it. The court, go ahead. What were you going to say?
I was just going to say, I think it's all my testimony.
I'm sure it certainly will, but I don't have that at this. It normally would during a bond hearing. I have to assess it based upon what I see, and I would say also, with all due respect to the magistrate of this court, that making a statement of giving a PR, but then indicating that the people might file an emergency bond motion, how she'd know that, I do not know. But that, from my perspective, leads the court to believe that it was in part of the court's funding, but also as a result of what the court is looking at in this case, would find that her decision to issue a PR bond was indeed an abuse of discretion in issuing that bond. The court will leave all of the conditions that she set in place. I will set the defendant's bond in the amount of $35,000 cash surety.
To wrap it up, the court set the defendant's bond at $35,000 cash, maintaining all safety conditions, after carefully considering compliance, past behavior, and public safety. This case highlights the importance of following courtroom rules and how judges balance fairness with legal obligations. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.